Hi, my name is Avril Love, and I wanted to thank Jen for inviting me to speak to you today. I'm going to tell you a little bit about myself. So I work for a law firm called K&L Gates. I have been a litigator for over 15 years, and I started out representing companies that are regulated by the FDA, drug and device manufacturers mainly. And in the last 10 or so years, I've really focused my practice on working with companies in the beauty and personal care space. And what I've found over the last 15 or so years is that by the time you're in a lawsuit, it's often really too late to do as well as you might have done because the facts are what they are. And sometimes you really wish you could go back in time and do things differently. So what I do now in my practice is I focus on litigation avoidance through risk management. What that really means is that I advise clients on all kinds of business decisions that they're making with respect to product design, advertising claims, marketing practices that may not have anything to do with the type of product that they're making. And then we talk about what the risks are of doing things a certain way so that clients can make informed decisions and put themselves in the best position possible if and when inevitably they get sued, which often does happen when you are successful. So, because I am a lawyer, I'm going to have to start with some disclaimers. This presentation that I'm giving is not legal advice. It's just for educational purposes. Also, if you have access to this slide deck after this talk, which I hope you do, that's great, but be aware that it is not going to include every single thing that I've said here today. And it's really just a subset of information that you may want to know in order to make decisions about your conduct. So be aware that this is not going to be completely exhaustive. The views that I'm sharing today are my own. They don't belong to my law firm. And most importantly, everything changes. So as soon as this presentation is over, it's going to be old. And while not obsolete, it's going to be something that you're going to need to look into and follow up on. It's very important to talk to a legal advisor who's up to date on things because things change very quickly. Regulations change, litigation can change things. And so it's very important to understand if you look back at this in a year or 2 years from now, it may be out of date. All right, and with that, we're going to get started. So I want to talk to you today about how to formulate product and design packaging, things that you may need to consider in doing that, what you want to do to protect your intellectual property, crafting legal advertising claims, and the data requirements for supporting those claims. And then importantly, marketing trends and litigation risks that are out there that you're going to want to know about. So formulating your product. A lot of times when clients come to me, they are doing that because they are getting ready to launch something that they've spent the last 2 years developing, and they want legal approval. And the truth is that by then it's kind of too late to be looping in a lawyer or a regulatory consultant because you may not know that there are laws restricting ingredients or requiring reporting. And those might be things that you want to know about when you formulate. So just keep in mind that there are a number of states that regulate ingredients, even though the federal government may not be doing that as much. And so there are a number of ingredients, particularly PFAs, that are seeing a lot of ingredient bans that are going to come into effect in 2025, but they're not the only ones. And California is leading the way, but again, also other states are also enacting certain ingredient bans that you're going to want to be aware of in formulating your product. Similarly, there are certain state agencies that regulate various areas. In this case, I have an example of the California Air Resources Board, which of course regulates air pollution and tries to minimize certain emissions like VOCs. So it's important if you're selling certain kinds of products, anything sold in an aerosol, for example, like a dry shampoo or fragrance, you're going to need to be aware of the CARB VOC limits for your particular type of product because the penalties for violation can be quite stiff. Also, there are going to be a number of states that regulate certain ingredients in that they require disclosure if you are using ingredients that are deemed to be potentially hazardous. California, again, leading the way here, and not so recently, 2020, enacted the FERCA, which regulates fragrance ingredients in particular for our industry. So it's really important to know whether any ingredients that you're considering in your formulation may in fact be listed on some of the lists that are deemed to be potentially hazardous ingredients. that would require you to report. And that's important because A, you might wind up having to put an ugly warning label on your packaging under Prop 65. Or B, very importantly, there are a lot of consumer attorneys out there who look at the publicly available lists of brands and products that include certain ingredients in their formulations. And they are, they are looking to sue you, and they are looking at these publicly available lists and sending out letters about the potentially hazardous nature of your product. All right, now packaging is another area where I probably wouldn't have been talking about this a year or two ago, but a lot of regulatory change has happened with respect to packaging as states are looking to minimize plastic waste in particular, and in regulating recyclability claims that are appearing on your packaging. So it's very important to know about states that are doing this, because we're going to see this more and more with extended responsibility programs for producers of packaging. And these laws basically shift the burden of waste management to the manufacturers and the packagers. And what they're going to do is require that if you want to sell product in the states that have these laws, you're going to have to be a member of a producer responsibility organization, which is going to collect fees based on how much you sell. And it's going to facilitate certain recyclability efforts in the states that are enacting these laws, and just generally managing how disposable packaging is made, what the contents of it are. And it's really trying to push to reduce the amount of virgin plastic that's used, to encourage producers to use compostable and recyclable materials. Another area that you're going to want to think about in advance is your intellectual property. It's very important for you to figure out what is it that you want to own, and how might you protect that? Because you may have a great idea and you're really excited to launch and to get sales happening. But you may find, in fact, that you do have a great idea and it's very successful. And now you've got copycats maybe in the market, and you want to make them stop copying your product. So you would do that through perhaps registering a trademark. And you'd want to, know in advance if anyone else is using the name that you want to be using. So that's something you can do. It's also in our industry very important to figure out who's going to own your formulas, because oftentimes contract manufacturers are making the formulas for us, and then they own the formula, but you may want to own the formula. So that's something that you're going to want to figure out in the relationship when you are drafting a written contract with your contract manufacturer, and be aware that a purchase order is not really a written contract that is going to have all of the terms that you're going to want in a written contract. So it's very important, have written contracts and figure out how to define the relationship and who's going to own what. Advertising claims. A number of regulatory bodies actually oversee advertising claims. Some of them are not government bodies, actually. So we have the FDA, which regulates cosmetics and drugs and other products. We have the FTC. The FTC regulates advertising for all manufacturers, all brands. And then we have the NAD, which you may not have heard of. It's not a government entity. It's actually a division of the Better Business Bureau. And the NAD works closely with the FTC. It's actually a private self-regulatory body for the advertising industry. But although participation in their process is voluntary, if you don't participate, they may refer you to the FTC. So it's very important to know about them if you get a letter from them, perhaps from a competitor challenging a claim you've made, and they also have a monitoring program. Lastly, and probably most importantly, because you're most likely to encounter these folks, will be the consumer attorneys. Class actions are a really big piece of what shapes advertising. And it's very important to know about litigation trends so that you can craft your advertising claims in ways that minimize the risk. All right, I know that you're going to hear from another speaker on the FDA and these specific laws that regulate cosmetics, so I'm not going to go into this in depth. What I am going to do is talk about the various products that FDA regulates. This is important to understand when you are talking about creating your claims, because the FDA regulates claims based on the product classification that your product has. You may be selling a cosmetic, you may be selling a drug, you may be selling a dietary supplement, which is a food technically. And depending on what category your product falls in, that is going to dictate the kinds of claims that you can make. So it's important to understand the definition and the differences between cosmetics and drugs and dietary supplements. Specifically, cosmetics are intended to be applied to the body, and they're intended to enhance the attractiveness or the appearance of the wearer. That is separate and apart from drugs, which are intended to treat, mitigate, or prevent disease or diagnose disease. And it's important to understand that cosmetics are not permitted to impact the structure or the function of the body. That goes beyond a cosmetic function, and that is really where a lot of risk comes from, because actually what cosmetics can do in the market may be different from what the law deems them allowed to do. So it's really important to understand this, because what you can prove that your product actually does is very different from what you are legally allowed to claim, depending on what product category your product falls into. The FDA has limits on claims, and they have nothing to do with what actually is true, but rather they're based on the intended use of your product as evidenced by your claims. So cosmetics can make claims that they impact the look and the feel of skin, hair, or the body, whereas drugs might make explicit claims about diseases, reducing inflammation, perhaps treating rosacea and eczema. But drugs also may make claims about the impact on the structure or function of the body. They can talk about how perhaps a compound affects cells. That's not something that is really a cosmetic function. Dietary supplements, on the other hand, have this sort of in-between position. They are actually allowed to make claims about the structure and the function of the body, but you wouldn't want to make drug claims around a dietary supplement. So for example, you might say dietary supplements boost the immune system, but you would not want to say dietary supplements prevent infection. Now, the FTC also regulates advertising claims, but it does that through a slightly different lens. It's not concerned about whether you're overstepping the limits of the product category that you're in. It's more concerned about whether your advertising claims are truthful and non-misleading to consumers. It's really important to understand that all of the claims that you make have to be supported by evidence before you make the claim in the market. And if you need to make some kind of qualifying disclosure to consumers to make a claim truthful, it's very important that that disclosure be made, and that it be made in a way that is really unavoidable for consumers to see it, even if they're looking at your advertising claim on their mobile phone. Likewise, a claim can be misleading if it omits information that would be deemed to be material to a purchaser's buying decision. So it's really important to make sure that you're offering the consumer all of the information that they need to make an informed choice. Now, a brand is responsible for all of the claims that it really makes about its product, regardless of where those claims are. So yes, it's very important that your product labeling be truthful and accurate, but you also need to be thinking about what you're saying about your product on your website, in your social feeds. And then you also have to think about, if you have relationships with influencers, what are they saying about your product? Because you're going to be responsible for what those influencers say about your product. Likewise, you're going to be responsible for consumer reviews that appear on any of your digital properties. And you may fairly or unfairly be responsible for consumer perception, meaning whatever a consumer takes away in terms of the message of your advertising, that's what you're responsible for. If they can reasonably take away a message, even if you didn't mean that thing, you're going to be responsible for that. So it's very important to have data to support all of the marketing claims that you make, whether those claims are explicit or implied claims. It's important to understand the concept of an implied claim because you might be making a claim that you don't really think you're making through visual advertising, maybe before and after pictures, or even through a color that you're using in conjunction with other claims on your website. So it's important to know that the FDA and the FTC are going to look at the totality of all of the claims that you are making, and that's how they're going to figure out whether you're making an express or implied claim about something that you need to support. I get the question a lot, how much substantiation do I need? How much data do I need to support my claim? What do I need? And the answer is that is claims driven. So you're going to want to understand how strong your claim is, and that's going to drive what kind of data you need. I've organized this list of sample claims from top to bottom in order of the strongest claim to sort of the least strong claim in terms of the support that it needs. So if you are making a claim because you sell a dietary supplement that your product supports the immune system, that's a health claim. And health claims must be supported with what's considered to be the gold standard of substantiation, which is clinical data. Likewise, if you refer to a clinical test, if you say something is clinically proven, well, you better have a clinical test. And if you are making a claim that is hard for a consumer to evaluate the veracity of on their own, because, for example, you use a percentage, some kind of numeric value for something like hydration, that's something that a consumer might have a hard time evaluating on their own. And so you're going to want to have clinical data for that too. Now, lots of brands really don't make claims about safety. Most brands don't make explicit claims about the safety of their product. But that is a claim that is always implied if you are selling a product in the market. It is always implied that your product is safe. And so it is extremely important that you have support for the safety of your product. That's also now particularly important because MOCRA, which just amended the FDCA, is going to require that you have substantiation for the safety of your product. Now, there is also sometimes an instance when in vitro data can be helpful. Typically, I don't think it is that valuable to have in vitro support for claims because that does not tell you a lot about how your product is actually going to operate when people use it. But you might make, for example, a microbiome claim that really cannot be proven other than with in vitro data. Similarly, you might be making a claim that requires survey evidence, like 4 out of 5 dermatologists recommend. Lastly, there are claims that may be easier for consumers to evaluate the truthfulness of on their own. And those claims are often best supported with consumer perception studies. That's not quite as scientifically reliable, but it's adequate for claims, for example, that your product makes hair soft and smooth, which is something that consumers can figure out on their own for themselves. And then lastly, there are claims that are just really opinion claims and are not really possible to prove because the issue is subjective. So whether your product comes in 3 delightful scents may actually not require any proof that the scents are delightful because that's just a matter of opinion. But you would want to have substantiation that there are, in fact, 3 separate scents, and you could substantiate that with your formulation. Okay, so this is a list of the various different kinds of data that you can use to support a product claim. And what's really important to know is that the legal standard for claims substantiation is really based on whatever science requires to support that claim. It's going to depend on the type of product that you make. So, for example, if you intend to be selling a product for health, that's going to require a very high level of substantiation. It's also going to depend on the claim that you're making. So as I discussed, you might have a claim that is easy for consumers to evaluate, but it might be hard for consumers to evaluate. And that's going to dictate the type of data that you need. Also very important, what is the scientific standard for the reliability of your evidence? And then what's the quality of your evidence? Does it actually show that your product does what it says it does? And is the data that you're using relevant to your product? So for example, if you're relying on a study of a particular active ingredient that you use, well, that study may have tested that active ingredient at a higher dose than what's actually in your formula. That's not really going to be relevant to your product. And so it's not very useful evidence to rely on. Similarly, if a test is done in a population of people that isn't your target market, that's not going to be very relevant, and it's not going to be helpful for you to support your claims. It's also really important to know that you need to look at the totality of evidence that may exist about your product or a particular active ingredient on which you rely. You are not free to ignore unfavorable evidence in making a claim. You can't just say, oh, well, look, there's this one study here that says this, so I can say that, and ignore evidence that might be contrary. You have to have a good reason to ignore any contrary evidence. And it may be that, there's some testing that isn't relevant to your target market. So you aren't going to consider that, and that's fine. But there has to be a scientifically reliable reason to indicate, to ignore any contraindicating evidence. All right, now marketing trends and litigation risks. A lot of litigation that I see actually doesn't have to do with claims at all. It has to do with how our clients market their products. And there are a lot of hot issues that we are seeing regulators and consumer attorneys focused on. Consumer reviews and influencers. So I talked about this a little bit earlier. It's very important, if you have relationships with influencers, that you have contracts with them so that you can regulate their behavior and monitor it and police their claims about your brand. It's very important that any influencers that you work with are familiar with the FTC's guidance on claims and disclaimers. And it's very important that if you are hosting consumer reviews, that you understand those reviews cannot say things about your products that you cannot say about your products. So if someone out there had a really great experience, but they've made a claim about something that you cannot support, that's not a review that you can host on your website without incurring risk. Similarly, there are a number of issues related to, let's say, negative review suppression, review hijacking, miscounting of reviews that are getting a lot of attention from regulators and are the subject of certain regulatory rules that are coming out. Green and clean claims are a very big, hot issue right now. Regulators are paying a lot of attention. Consumer attorneys are paying a lot of attention. We are going to see a lot of litigation around these kinds of claims. So it's important to follow the rules that exist and make sure you're not greenwashing. The best thing to do is to use narrowly tailored claims that you have evidence to support. Subscriptions. Lots of brands want to sell their products on subscription models, and that's fine. But it's important to know that something like 33 states have auto renewal laws that regulate those kinds of subscription models. And you've got to follow the rules related to what disclosures to make, whether your consumers are going to get reminders before an auto charge, what the cancellation options are. The FTC has proposed a new rule that will require click to cancel when it goes into effect, which is not something that a lot of brands are doing yet. So it's very important to know about these rules and to avoid what are called dark patterns, where you kind of hide important information because maybe it's covered under a banner and it's hard to see on a mobile phone. Consumer privacy is another really big emerging issue. 15 states have now passed consumer privacy laws that offer comprehensive rights to consumers. Those laws are not all in effect yet, and they won't be for some time, but some of them are. And they may not affect your small business yet, but it is important to know about them because consumers are starting to clamor for these rights. And also because these privacy laws have spurred consumer litigation around consumer privacy, maybe not under these new laws, but under old laws that are being sort of Frankensteined into new things. And so it's important to understand what your marketing department is doing, what marketing tools you are using, because a lot of them do involve tracking of consumers and sharing of data with analytics partners, with pixel tracking. If you have videos that you offer on your website, and where viewing history is available or shared with vendors, that's something that can expose you to litigation. And so it's very important to be aware of what tools you're using to market and whether there's data sharing so that you can avoid trendy consumer litigation. All right, so I know that's a lot, and I'm just going to give you the key takeaways. Design your formulas and your packaging with new regulatory rules in mind. It can be very expensive to change your formula or your package. It can take a long time, but those are issues that create a lot of risks, so it's important to get it right. You want to protect your IP. You need to plan what you're going to own, and then it's very important after you do that to monitor what your competitors are doing in the market and enforce your rights. If you don't enforce your rights, you can lose them. Craft your claims consistent with your risk tolerance. Ultimately, it is a brand's decision. Someone like me can tell you what the risks are, whether you're making a drug claim or not. At the end of the day, it is going to be your decision what claims you want to make, how much risk you want to take. But it's important to know what those risks are so that you can make informed choices and make sure that you have as much data as you can to support your claims and minimize risk. You want to make sure your data is reliable and it's going to stand up if you have to defend it in court. And then lastly, you want to monitor your marketing practices to avoid any pitfalls in litigation. And with that, I'm going to open it up to questions.